Troy Williams with Williams Realty Partners and Keller Williams Coastal Realty here in York, Maine.
And I'm Kathryn Bedell, attorney, practicing in estate planning, elder care, and all things real estate to do with estate planning.
Makes sense for us to meet today. I mean, real estate is really the biggest part of estate planning.
Absolutely.
It kind of goes hand in hand. Wanted to talk to you about some of the questions that I get asked often from clients looking to buy property and how best they should take title with different things. A lot of people don't even realize there's different ways to take title.
Absolutely.
Can you talk on that? Like, if someone, married couple looking to buy a house, what are their options?
Well, the first, and I would say the most common option is joint tenancy. Mm-hmm. The thing to remember with joint tenancy is there's that automatic right of survivorship. So if one spouse dies, the other spouse automatically, without going to probate, without doing anything, owns that and can go and do their closing. Joint tenancy doesn't have to be spouses. It could be a parent and a child. It could be siblings. It's just that kind. It could be more than 2 people. It can be 10 people. It's just that last, as you die, you fall off ownership.
So if there's not 10 people, but 4 people, and one dies with joint tenancy, the other 3 then just absorb that share?
Absolutely.
No probate?
No probate.
No
it doesn't
court.
matter what your other estate planning is. That joint tenancy deed is going to control over everything.
Wow.
Okay.
So even if it's a property that they own as a business or a rental property, say, it doesn't matter.
Yeah, and so if you want joint tenancy, you got to make sure you are joint tenants.
Yeah.
If you don't want joint tenancy, some people are joint tenants and they didn't even realize it. They wanted it to actually be more like, I own a half and you own a half, and if I die, my family gets my half, your family gets your half. That's not what joint tenancy is.
What would that be?
If you wanted to do something, that would be called tenants in common.
Okay.
And you bring up a great point, because in Maine, if you aren't joint tenants, we actually have to use the word joint tenants in the deed. Otherwise, you are presumed to be tenants in common. So I have a lot of couples, and I'm sure you've seen this, where spouse A dies and spouse B thinks that they own the house. They think they're joint tenants. They go to the closing and they find out, sorry, you weren't. We didn't see those magic words in your deed. And so now you're going to have to go through probate. And it really is troubling to that surviving spouse.
So the last thing they want to have to deal with.
The last thing. Yeah. It's just 2 little words. But if it's not in your deed, you are not joint tenants. So whether you want to be tenants in common or you want to be joint tenants, you just have to go check your deed. It's going to be in the first few sentences. Your seller grants to you as buyer, and you're looking for whatever you want, a joint tenancy or perhaps tenants in common if that's what you want.
Does it have to say, I'll see sometimes, joint tenants with rights of survivorship?
It doesn't have to say rights of survivorship. Our statute, the legislature dealt with this specifically and said, we'll take anything. We'll take joint tenancy, we'll take just rights of survivorship. But if you don't say something like that, you're tenants in common.
Interesting. Another thing I see a lot is first-time home buyers, young couple, not yet married, but want to buy a house. They're renting and they're like, why are we doing this? Both have good jobs. They want to buy a house. And then we get the thing from the title company and they go, oh, they want to know how we want to take title. How can we do that? And I said, well, it's up to you guys. But what are some of the, in that situation, is there something that they should be mindful of? Can you speak to that?
Absolutely. I think that if you're not married, whether you're joint tenants or you're tenants in common, that's up to them. They need to understand the difference.
Yep.
That do they want that right of survivorship, or do they want it to go to their children or family, whatever that half is, or because
with tenants in common, they would, if one of them were to pass, the other one wouldn't automatically get it. It would go to their heirs, right?
Right. Or what their estate planning said. The thing that I always emphasize with non-married people is you do not have the divorce laws to back you up. So you're just on that deed.
Yeah.
together.
Yeah.
So, and if one wants to sell, one doesn't want to sell, you guys break up, whatever, that can get complicated.
Oh, yeah.
So a simple co-ownership agreement, which is not expensive. My co-ownership agreement is like 4 pages long. It's not fancy. It just says, okay, this is how much I contributed. This is how much you contributed. This is how we're going to pay our expenses. This is who owns, how many percentage. Sometimes it's 60-40. I see all kinds of things.
Yeah, it doesn't have to be 50-50. It could
Right,
be, yeah.
right. And if we decide one wants to leave, this is what we're going to do.
Yeah.
And so co-ownership agreement, necessity.
I'm surprised we don't see more of that. Does that get recorded?
No.
Okay.
No.
Do you keep a copy of it, though, I imagine?
Yeah, yes, absolutely.
Yeah, that's great. Another one that I see often is we'll have like a brother and a sister and their spouses and their families looking to, buy a summer house together, kind of go in on it and share it. What are the options for them? What would that co-ownership agreement actually sounds like a good idea?
Yeah, that 100%. That would work great for them as well. There's a couple of options that I see. So you can own couple number one can own as what we say joint tenants as to each other.
Yep.
It's called inter se. Sometimes you'll see that in the deed.
Yep.
But there'll be tenants in common as to the other couple. So in other words, there'll be a right of survivorship for that couple, but then as to each other, one owns half and the other owns half. So that's option number one. So I will see that.
Yeah.
Option number two, for not a lot more money, they can get together and do what we call a nominee or a realty trust, which is a very simple trust that mimics that ownership. So it says, one half is owned by these two people as joint tenants, and I can even, because it's a trust, I can even say that at their death it goes to children or whatever.
Yep.
And so it can be very reflective of that ownership. But the great thing is that if they're out-of-state residents, they avoid probate. So one thing people always have to remember is that the state you live in does not have jurisdiction over anybody else's real estate, any other state's real estate. So, for example, if you have, which I know you do, have many out-of-state people buying property in Maine, and they are going to, if they're just on that deed, their name alone, they will subject themselves to probate in Maine.
Oftentimes they don't realize that.
No.
They go, well, I probated my home in Massachusetts or wherever. I'm all done. Not
no,
quite.
and that can hold the closing up, because you all of a sudden realize, because you don't know, and it doesn't really dawn on anyone until you guys get involved.
Right.
And then it's just like, all right, you got to go hire a lawyer and you got to do the probate. It's just something that out-of-state residents definitely need to, I think, try to avoid probate in Maine. It just makes it so much easier for the people you leave behind.
With those trusts, can they still get a mortgage or finance the property?
Absolutely,
Okay.
absolutely.
Oh, that's
if
great.
it's a revocable trust, we're not going to go into the weeds of irrevocable trust, but revocable trust, which is what we're really talking about, are freely alienable. And then there's another option that not many people know about. So I'm happy we're talking about this subject. Is Maine is one of the few states in our area that has adopted the Uniform Transfer on Death deed, which is basically you can name a beneficiary on your deed. So I always tell people it's like your deed stays the same, so it's still whoever you bought it from. Mm-hmm. And then you can put a new deed on top of that says that at my death, it goes to my kids. So joint two married
that
people.
Seems really simple. It's almost
so simple.
Yeah.
I love these deeds. I do a ton of them. They're very popular, and we've had it since 2019. So people are getting used to these deeds, and they're really handy. They, like I said, an out-of-state resident or even an in-state resident. If you have a very simple estate plan, like it's just going to go to the kids. The joint tenancy would lie underneath that, and then at both deaths, it would go to whoever they named. I wouldn't put more than like maybe 1 or 2 people, and they got to get along.
Yeah, right.
Because you know how it is. If you go to a closing and people don't agree, it's not good.
Right.
So
it doesn't always close.
Yeah, it doesn't always close. So you don't want to put, because it's, I always say those pay on death deeds or transfer on death deeds are very stick figure-y because they're not for everyone. You can't do anything fancy.
I think you kind of mentioned it. That's like a good option for somebody who maybe their estate size may not be, super large. That might be really all that they need, that and a good will maybe.
Yep. Yep, absolutely.
How often, so with estate planning, my parents, they got their trust done and they're like, we're all done. And I think a lot of people think like once they do that, they're done. But really the trust is just the first step. I mean, should you take another step and put things in the trust or, update it at some point in time? It seems like it'd be nice if it was all done, but like life happens and things change. How hard is it to update that after you've, put it together?
Not hard at all. And I think you raise a great point. One of the number one pitfalls of doing a trust is that it doesn't mean anything unless assets are actually owned by that trust. So you actually have to do a deed into the trust. You actually have to put a bank account into the trust, a car into the trust. There's work to do.
Yeah.
And so what happens, I'll see a lot of clients, especially that maybe have been down in Massachusetts, they had all their work done, and then they came to Maine and they forgot about the trust. So they bought the house in Maine, not in the trust. If it's not in the trust, then the probate avoidance, all the nice things about the trusts are not going to be applicable. So I generally see people, so for people who have trust, I always say you have to have constant vigilance. You need to be aware of how they work, and you need to be very savvy that you're constantly monitoring your assets to make sure that everything that you own is in that trust and everything's buttoned up. But I generally see families probably twice in their life. The touch point times are after you have kids. You definitely, there's something called a testamentary guardianship. You want to have a will. If something, God forbid, happens to both parents, there is an automatic appointment of the guardianship if you have that in your will. So there's no court case, there's no nothing. It's just an automatic appointment, no different than if a personal representative is appointment. Judge doesn't even get involved. So it's really good to do it. And then when you're young, and then the next time I see people commonly is when they're ready to pass that baton on to the children. So maybe late 50s, 60s, sometimes even 70s, you'll get the people who are like, oh, I haven't done anything.
I know
I'm
I
like,
should have.
fine, you're going to be fine. You're here now. It's very hard for people to do this.
A lot of them don't want to think about it.
No, I can't tell you how many people say to me, I'm convinced myself that if I do this, I'm going to die the next day. I'm just like, but that's, people feel that.
The data doesn't back that up.
I know.
We haven't found that. Well, I think this is very helpful and very informative. There's a lot of questions around this, and I think it'd be good if we did a seminar maybe this spring. Seminar may not be the right word, but an informative Q&A type thing, presentation. We've got a training room in our new building in York that you and I share. And, I think that'd be cool. We could have some people come in, maybe prepare questions and, go over a little more different options and things. Yeah,
I'll be there, and it'll be a free lawyer for however long they want us there.
Yeah, we'll put that the link and more info in the video, and hopefully see you guys there.